Hi, good morning. Today we discuss something with regard to arbitration law and specifically with regard to the question of limitation and whether the same can be decided by the High Court when appointing an arbitration under Section 11 of the Arbitration and Conciliation Act. A lot has been said about this and a lot of legislation and a lot of judgments have followed. Let's pick it up. Initially, when Section 11 was introduced in 1996 Act, there was no real that much clarity. Clarity came in 2006 when we came into the judgment of Patel Engineering, where the court, Supreme Court that is, clearly held no with regard to these issues. Before an arbitrator is appointed, the court really need to look into whether it can be sent at all to the arbitrator. As a result, what happened is courts were clogged up with a lot of cases where people questioned the matter of, other than the other points involved, also the question of limitation. It is true, the question of limitation, as all my friends who are dealing with laws regularly would know, deals with a mixed question of law and fact. That being said, a question of limitation should ideally always be decided by the Supreme Court or the High Court when appointing an arbitrator, because then it will unnecessarily not involve people into costly litigation, as arbitrations in India are extremely unaffordable. Extremely unaffordable. Now, however, this continued, this entire thing, jurisprudence continued for ages till we come to 2015-16 when you suddenly had the new amendment to the Arbitration and Conciliation Act, and thereafter the other amendments which followed, which introduced a new provision which being Section 11(6)(a) of the Arbitration and Conciliation Act. Now, what does this provision do? This provision puts in that irrespective of whatever Supreme Court judgments have come before this, when an arbitration application is put forth before a High Court or a Supreme Court for appointment of an arbitrator, the High Court can, or the Supreme Court for that matter, can only look into the existence of the arbitration agreement. That's it. There cannot be any more judicial scrutiny beyond this. Now, why suddenly? I guess the more impetus was perhaps to give a kind of situation where international arbitrations were getting held up in India. I don't think the legislators really thought about the domestic arbitrations which will get mired into the problems which happens when clearly time-barred debts are suddenly put up for arbitration and the other side is harassed through arbitration process. So this came in and all the courts got looked into this legislation, and thereafter the Supreme Court in Duero Felguera said that this is very correct law and the courts can only look into whether the arbitration agreement is there and whether it is valid. Beyond that, nothing. All of that goes into the realm of the arbitrator. You go to the arbitration and the arbitrator will decide whether it's time barred, whether it's any other jurisdictional issues, whether it's arbitrable, everything. This is what happens. Then comes the new amendment in 2019. The amending act of 2019 deletes section 11(6)(a). So that provision which took away which changed the law from what it was for almost 10-15 years was again deleted. I'm sure why it was deleted, well, we will perhaps never know, but I think the legislators came to understand what problems came to people who went into arbitrations knowing fully well that these are time barred, they were not jurisdictionally correct, what something perhaps was not arbitrable was being sent into arbitration because there was an arbitration clause and the courts could not look beyond. So, this amendment comes into being. However, interestingly, that portion of the amending act has never been notified. Now, what does this mean? Most of us are aware of the fact that amendments to a central law would be first passed in the Lok Sabha and then by the Rajya Sabha. But then there is another portion which says that it comes into effect only when it is notified in the official gazette. Now, there has been a situation with many a law that it has never been even notified in spite of the fact that it has been passed by Parliament. Whether it is an indication of legislative intent, whether it is something that derives upon legislative intent, that is a separate topic altogether. But today the situation is that the both houses of Parliament have passed the amending act deleting section 11A, but it has not been notified. As a result, the law continues, and even though most of the BEAR Acts, Arbitration and Conciliation BEAR Acts today contains the section 11.6a as a deleted provision, but in effect it is actually the law. Section 11.6a still remains the law, unfortunately. Now, that would have meant that the proposition as laid down in section 11.6a and affirmed by judgments of the Supreme Court in Bureau of Alguera would rule the roost, and that would be the law. Now comes the bigger twist. Two new judgments come in. One is Vidya Drolia in 2021, the second Vidya Drolia case, 2021, and the new judgment of Bharat Sanchar Nigam versus Nortel Networks, which I guess has been passed sometime in 2000 and this was passed on 10th of March 2021. Now, what do these judgments say? These judgments say, well, they take note of the fact that because of the amendment, because of the introduction of section 11.6a, the entire ratio and what the law was prior to that through Patel engineering is no longer the law. That's no longer. No, but they again make the law ambiguous. They say that in certain cases, when it is really very clear on the face, ex facie, that it is time barred, that is not arbitrable, then the court can step in even at the stage of under section 11, and prior to appointment of an arbitrator, it can dismiss the arbitration. So now the fight will be not on question of arbitrability, but whether it is ex facie not arbitrable, ex facie limitation. Now there is, well, they say that it is a very thin line, only on certain cases, but really I don't think there was any requirement of making the law more ambiguous than what it is. The law was clear, it was changed, and all kind of problems cropped up because of the new amendment and introduction of section 11.6a. That amended provision gets deleted by a subsequent amendment, but unfortunately the central government has failed to notify it, so that has not been given effect to. Now there are Supreme Court judgments which say that, well, in certain cases, ex facie, when it is absolutely clear, then, well, the Supreme Court can, or the High Court can still dismiss the petition and not refer to arbitration. I think this is the road which we have taken, but it is only ambiguity which is propounded. If we have to follow the unfortunate law which is there in section 11.6a and affirmed by the Bureau of Alguera, let that be. But compounding that with ambiguities and saying only in certain cases, what cases, will again lead people to quagmire of long-ended litigation. Thank you. Please have a look at these judgments, and I'm sure people will come to a similar view. Thank you. Bye. And if any kind of requirements are there with regard to citations or anything, please feel free to write to me on this thread, and I will provide everybody with all the details. Thank you. Have a nice day. Great time.